Welcome to Navigating Consumer and Family Law Challenges. Insights from SoCal's trusted attorneys.
Welcome to Navigating Consumer and Family Law Challenges with Amanda Hill and Sarah Kosrobati, partners at KandHLawGroup. Today, I'll be speaking with Miss Amanda Hill. We will focus on family law, consumer protection, and employment law. Amanda and Sarah offer compassionate, strategic legal guidance for real-life challenges facing California families. I'm Evan Mack, and today Amanda is diving into a recent national headline about a father charged with murder after allegedly overworking his son to the point of death. It's not a California case, but what if it happened there? How far can a parent go before discipline becomes abuse? And how do family court, CPS, and criminal law intersect when tragedy strikes? This is Too Far, when parenting turns into abuse. Hello, Miss Amanda.
Hi, thanks for having me.
Absolutely. So let's start with the headline. A father is charged with murder after his son dies during extreme physical punishment. If this case happened in California, what charges might the father be looking at?
Yes, so I will preface that I am not a criminal attorney. There are experts out there that deal with the criminal aspect of it. But in general, child abuse could be an aggravating offense as it relates to any criminal charges. There's going to be an extensive background and history looking at what if there was any previous calls to child protective services, child welfare services, and what was the physical abuse? Was it over a short period of time, a long period of time? So yeah, it definitely unfortunately happens. And there's complexities there because there's an overlap between what happens in with the child welfare services investigations, and if there's a history there that obviously ultimately results in something very tragic.
So at what point does this whole, the quote unquote tough love legally cross into child abuse under California law?
In general, under California law, you can use corporal punishment. I know a lot of people go, corporal punishment, that sounds like a military term. It
Right.
really just means physical punishment. A lot of people, the best analogy is, spanking or hitting your child. In California, the general rule of thumb, but again, I will preface the law is always changing, is you can use corporal punishment as long as you don't leave a mark that lasts for more than a day, so to speak. Now, there is wiggle room there, right? It depends on the age of the child. It depends on what the specific circumstances are. But yeah, let's say you have a 6 or 7 year old and they're acting up and you've told them multiple times and you swat them on the bottom, you're certainly not going to be caught up for abuse on that. But, if there's a situation where, you have a handprint on somebody's bottom and they go to the doctor and the doctor sees that, there's probably going to be an open investigation.
Wow. So would CPS get involved before a criminal case is even filed? And if that's the case, what's that process like?
Yes, in general, the only way the criminal or the prosecutors or the police will get involved and there's a criminal investigation is is when child welfare services first gets involved, or sometimes the police gets involved and they see it's a form of child abuse and there needs to be an open investigation with them. They will then give a call to child welfare services and get them to do the deeper diving into the history and background of this family. So they usually work hand in hand together. Sometimes one will get involved first over the other, especially if it starts out as a smaller issue, so to speak, emotional abuse, allegations, or maybe the child's in therapy and says something in therapy. Obviously, that therapist is a mandated reporter, and then they will have to make the report to child welfare services. And then from there, once child welfare services gets involved, they have to analyze, okay, do the police need to get involved? Does it rise to the level where now we're not just investigating a civil issue where maybe this child needs to be protected and taken from one parent or both parents? Is this an issue where it rises to a level of criminal liability? And to kind of dig a little deeper on that,
Yeah.
unfortunately, there's investigations that can last up to 60, 90, 120 days because of the backlog in the system. So it's not a quick and easy, I make a quick phone call and that child's being taken out of that household. It's usually very lengthy and complex investigation.
What rights does the other parent have if they suspect abuse but don't have, physical custody over the child?
So if they're in a co-parenting relationship and the other parent has primary custody and they're worried about what's going on in that other parent's household, You can always do what's called a welfare check, where Child Welfare Services is able to go out to the home and do an investigation and see how is the child doing, speak to the parents, usually speak to the child, maybe talk to individuals at the school. Again, though, it's going to be a very quick investigation depending on what the allegations are, right? If the allegations are physical abuse, the investigation is going to be more in depth. If it is something about you're brainwashing our child into certain things, or you're brainwashing our child into hating me and not wanting to come for their visits, okay, that's not going to be the same level of investigation as I think my child's being beaten as a form of punishment, in their other parent's household.
I kind of got a random question for you, but this is what you do. You're smart enough to understand this. I'm sure, even though it's out of left field. What about a parent that's kind of like withholding like education from a child from the other parent? You know what I mean? They have custody. It's kind of co-parenting, but while they're in custody of their child, they're like self-teaching them, but in their grade level is not kind of like normal with their age. Like, is that a form of abuse in California or anywhere else, you think?
I mean, I can't really speak to other states, but in California, that would be more labeled as neglect, because as a parent, both parents have an obligation and a responsibility to take care of the child, make sure they have shelter, clothing,
Right.
go to medical appointments. And then the other one is education, right? After the age of 5, they have to have some form of education, whether it's in the regular public school system, private school, or homeschooling. But yeah, if they're not, taking the child to school or teaching them the curriculum that's required by the state, it is a long process. But if your concern is that the child's falling behind, it does become a family law issue, where you could potentially go back to court and show the judge, hey, look at these school records. At this point in their education, they were doing much better, or under
Right.
my care, they were doing much better. And now they're falling behind, and this parent has primary custody. I'm worried about, what's going on in their household and what the long-term implications going to be to our child if things aren't restructured as far as our parenting plan. So that's like an example of what could potentially happen if you're seeing a pattern of issues when your child's coming back into your care in education issues, for example.
Miss Amanda, can a parent lose custody over a harsh discipline, even if it doesn't rise to criminal charges?
Yes, absolutely. Because if the issue gets brought before the family court judge, and that family court judge decides, you know what, even if the DA is not going to charge criminally, I still think it's in the best interest of the child on a long term basis to have a different structured parenting plan, or to be with the other parent, because I'm concerned about what's best for this child.
Right.
The biggest difference between criminal court and family court, right, is one's criminal, one's civil. But the biggest issue when it comes to children is there's a much higher threshold, right? You can't just, they don't file criminal charges on every case. It has to rise to the level that they think they can actually convict that person in court, or it's
Mhm.
not worth the DA's resources, to speak plainly, unfortunately, right? To
Right.
invest, to press charges in that issue. But it doesn't necessarily mean that in the family court, that family court judge, their responsibility is to look, I'm going to make a decision on this issue based on what's best for this child. And that's a different threshold. That's a different standard and analysis that they do.
What about balancing? How do judges typically balance that, the parenting style versus the best interest of the child?
So, parenting style is just one factor that the court can look at. In fact, I've heard many judges, lecture, so to speak, both parents when they're going through a hotly contested custody case about, listen, ma'am or sir, you can't micromanage the parenting style. Now that you guys are no longer under the same roof, you can't
Okay.
micromanage the parenting style of the other parent. Now, if it puts that child at, a health or safety issue, of course, then that's something different. But if one parent is more relaxed and doesn't believe in corporal punishment, and maybe doesn't believe in, um, you know, believes in a different way, for so to speak, you get rewarded instead of getting punished, or you have a chores chart, or whatever it may be. The judges are definitely not going to micromanage how each parent parents in their own home. But again, if it rises to a level where it's impacting the health or safety of the child, then sure, the court's going to pause and see, okay, what do we need to look at here?
What happens if there's another child or a kid in the household? Could they be removed or protected automatically, just kind of just based on what happened to another child?
Yes, absolutely. They're going to look at the age of the child. They're going to look at, is that child also at risk? In fact, that's one of the questions that Child Protective Services or Child Welfare Services looks at in evaluating the safety of the whole family unit. So if there's allegations as it relates to one child, if there's other children living in the home, they call them at-risk children or other children in the home at risk. And yes, they will remove that child if they determine the child directly related to the allegations is at risk.
From a legal strategy, in your opinion, what should a parent do if they are falsely accused of child abuse?
Well, it's all about documentation. It's all about proving your case in court, right? Do you have documentation to prove otherwise? A lot of times, if those are big, bold accusations to make. And the California legislator actually has codified and said if you make false allegations maliciously or on purpose to gain in a custody case or in a divorce matter, you can actually get custody stripped away from you.
Wow.
So because of that, right, you have to, if somebody's bringing forth those allegations and if they're completely heinous, they're completely false, there's no truth behind them, you need to get your ducks in a row as far as your documentation to be able to prove that in court, right?
Mhm.
And to be able to show, that's not accurate. For example, third party declarations, maybe from a therapist, a school teacher, maybe extracurricular coach, football coach, something like that, that can say, I haven't seen anything related to these allegations, right? But yeah, those are just examples, of course, but it's going to depend on each individual circumstance as to what's the best strategy in proving them that the allegations are false.
And on the flip side of that, if someone is worried about what's happening in the other parent's home, how should they document and escalate it safely and legally?
Really, I hate to say this, but I'm a parent myself as well. And
Right.
there's that parental gut instinct that you feel
Mhm.
about the safety and well being of your child. And if you get that gut, the first thing you need to do is obviously speak to the child to see if this is really something that you know, uh, that you feel they're confirming. Now, obviously, that's going to depend on the age of the child if you're dealing with a 2-year-old who's not going to be able to comprehend that complexity. So, you can go to child welfare services. You need to also be prepared with getting your evidence together, your documentation together. Unfortunately, photos, if it's physical abuse, if you see bruising or scratch marks or, welts, things of that nature. You want to go to the school if the child is school age and see, have you noticed anything, difference in behaviors, anything like that. So that, because unfortunately, and it's no fault necessarily to the child welfare services system, but they are inundated. And since COVID, they have been that much more inundated with child abuse cases. Unfortunately, it's a sad statistic. And so they have, a certain threshold before they actually go and investigate. So you want to see, you know, is it to the level where I need to investigate or have child welfare services investigate? But of course, if it's something very egregious, you call 911 or you call the police because you want to get them involved as well. If it's something rising to the level very extreme.
Ms. Amanda, thank you for your time and your insight on this matter. Thank you so much.
Thank you for having me.
And thank you all for tuning in to Navigating Consumer and Family Law Challenges. If you or someone you know is navigating a complex custody situation or has concerns about child welfare, Amanda and Sarah are here to help. Visit KandHLawGroup.com for more information. And don't forget to like, subscribe, and leave a review. Thank you so much for watching.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.